Hello, I'm Stephen Gold.
And I'm the author of The Return of Breaking Law.
Yeah, stop messing about.
Here come the judge. Here come the judge.
If you're not a lawyer, you may wish to pop outside for a vape or catch up on the box set of Ealing comedies whilst this goes on. CPR amendment rules and a new practice direction, that's number 171 and still counting, it kicked off on the 1st of October 2024. Well, here's my pick of some of the more exciting bits. Fix recoverable costs came in a year ago. Fix may be, but there could still be areas of dispute on how much the loser should be paying. Well, there hasn't been any satisfactory procedural route so far for getting a dispute like that settled, but there is now. It's a shortened assessment and it's called Fixed Cost Determination. Good name, eh? It's covered by CPR Part 45, Section X. The trial judge is still meant to deal with costs at the end of a case where possible, so a new shortish form has been devised for a party who intends to claim fixed recoverable costs. It's precedent U at the trial. And it's got details of what the fixed costs are asserted to be and of any claim for them to be exceeded or uplifted. And if a judge, for whatever reason, doesn't deal with the costs at the end of a case, they can direct one of these fixed cost determinations, with or without a hearing. It will be treated as an interim application. Now, supposing there has not been a trial because everything's been agreed apart from the fixed recoverable costs, whether or not proceedings have actually been started. Well, that's where the shortened assessment procedure kicks in. If proceedings have been started, this will be by way of a modified Part 23 application. But if proceedings haven't been started, it will be by way of a modified Rule 46-14 costs only claim. There are provisions for the filing and service of evidence in support and response, and the determination will be made on paper but can be challenged at a requested hearing. The requesting party pays the costs of that hearing unless they achieve a reduction of at least 20% on the paper determination. The defendant must be given not less than 14 days prior notice of the eviction date, unless they're a trespasser. And that's by a prescribed form being delivered to the premises from which they are to be ousted. The court can shorten that period down to no notice if asked. But what if the defendant isn't ousted on the original eviction date and a later appointment has to be notified? Well, this was a bit of a grey area, but it's now clarified. At least 7 days' notice for any subsequent date required, and also by way of a prescribed form. Again, the court can shorten time. The legislation on our withdrawal from the EU is likely to give you the twitches at various locations of your body. A procedure has been established for any challenge to the application of any EC law that we have retained. Don't you know? Well, that procedure was due to come into force on the 1st of October 2024. The good news for you is that it has just been halted. When will it come into force? Answers, please, on a postcard.